UK. So an overview of what we're looking at today, the first thing we'll be looking at the Great Wealth Transfer, looking then to the changes arising from the autumn budget, estate and succession planning, other considerations, the impact of the autumn budget on private client disputes, and then looking forwards to what may come next. So over the last 12 months, the UK has had a lot of change to digest. We've got the first Labour government in 14 years. We've got a lot of new MPs sitting for the first time in Parliament. We've had the autumn budget, the return of Trump and the agenda of America First, and the continuing wars in Europe and the Middle East. So when change began there was announced by Sir Keir Starmer after winning the general election, I'm not sure everybody expected the level of change that happened even within the first 100 days. The Labour government announced 39 bills. They covered a range of topics, and they announced the largest tax raising budget since 1993, seeking to raise about £14 billion with a focus on national renewal and to plug a growing black hole in public finances. So much of the UK's wealth is currently held by the older baby boomer generation, and it is estimated that around 5 trillion to 7 trillion will pass to the younger generations over the next 30 years. So looking at the Great Wealth Transfer as it is known, I thought it would first be useful just to highlight and work through what we know as different generations and what they are known by or when they're born. And who would fall into that bracket. So the greatest generation, of which I believe there's about 250,000 people, are those born between 1901 and 1927. And then we have the silent generation, which was born between 1928 and 1945. The silent generation was the first defined generational group, and it was people who lived through World War II, and there's approximately 4.3 million people. Their name comes from an article in Time magazine from the 1950s and alludes to the fact that the children of this generation were taught to be seen and not heard. And then we come on to the baby boomers, which we often hear about as being the ones with all the wealth. So they're born between 1946 and 1964. Now that may change depending on which reference you look at, but they relate to the huge group of people, the surge of births after World War II. So you're looking at approximately 13.6 million people, and generally they were afforded with incredible ability to make or take advantage of the situation. So in terms of, they had a strong economic growth following World War II, they had an affordable housing market, strong job market, and booming equity markets. And again, it's estimated that between the baby boomers and silent generation, there will be 5 to 7 trillion pounds expected to pass over the next 30 years. And then we have the groups that follow. So we've got Generation X or Gen X, born between 65 and 1980. The generation that typically experienced technology and the developing, so they kind of bridge the gap between the digital and non-digital world. And that is about 14 million people in 2023. The group of millennials or Gen Y, typically the children to the baby boomers, are those born between 1980 and 1996. The first generation to be typically known as digital natives, as they no longer have to rely on others to solve their problems or to teach them things because they have the internet. And again, this is estimated to be the biggest group, but it is around 14.6 million people in 2023. And it is typically, as I say, the largest cohort considered to happen at the moment in the UK. And outside of that, just to give you the kind of finishing off, we've got Gen Z or Zoomers, born between 1997 and 2012. Largest generational group globally, and in the UK, that's approximately 13.2 million. And then we have Gen Alpha, born 2013 to present, mini millennials, approximately 8.3 million people, and Gen Beta, which is for people that are born from now to 2039. And just to comment at this stage that the UK population has been steadily getting older, and the trend is projected to continue for the future. Typically, there were about, in terms of, we've got 2016, we've got 11.8 million UK residents aged 65 and over, representing 18% of the total population. And before, 25 years before that, that were down to 9 million and accounted for just over 15%. So we're looking at the baby boomers moving into the older ages, and by 2066, it is estimated that there will be a further 8.6 million people that are aged 65 years and over, taking that group to over 20 million and up to over 25% of the population, which has knock-on impact when we look at services demands, especially around social care and housing and pensions. So we come on to the changes and why is this important on the horizon, and the big announcements that were made in the autumn budget. The first big one came down to inheritance tax. So the pre-budget, it set out the allowance known as the nil rate band as 325,000 allowance before inheritance tax became due, with any unutilised threshold being added to the spouse civil partnerships once died. Now, that remains frozen for a further 2 years, meaning that nil rate band and residence nil rate band will stay the same at 325,000 and 175,000 respectively until 2030. This protects up to £1 million in the state for inheritance tax purposes if you are in a civil partnership or marriage, but unfortunately it doesn't allow for any raise in line with inflation or otherwise, and it has not been raised since April 2009. If it had been, we would expect it to hit the threshold of around 500,000. Ultimately, that does mean that an increasing number of states, before all the amendments were made in the autumn budget, put the states into paying inheritance tax. And this is on top of the generation of the baby boomers, where 5 trillion to 7 trillion is expected to pass in the next 30 years. We come on to the one that seems to make the most noise at the moment, which is because the farmers are up protesting often in Whitehall. And we've got agricultural property relief and business property relief. Now, pre-budget, there was no suggestion, I would largely consider there would be no amendments or tinkering with APR or BPR. And at that point, farming and qualifying assets and business qualifying assets effectively were provided with 100% inheritance tax relief, basically meaning that they did not have to pay inheritance if they were able to show that they qualified. Now, that all changes from April 2026, and dependent on the consultation and the proposals that come through, effectively 100% of inheritance tax relief is available for agricultural and business assets, but they only apply to the first 1 million of such assets, with 50% of inheritance tax relief available thereafter. This effectively means that inheritance tax due will be paid at a rate of 20%. What is also key here is that what the £1 million allowance left over cannot be transferred to a surviving spouse or civil partner. And transfers into trust of assets that benefit from agricultural property relief or business property relief and gift transfers, where a settlor has set up more than one trust before the 30th of October 24, meant that each trust would have had its own £1 million relief allowance. However, after that date, any trust set up for that purpose would allow for a £1 million allowance to be shared between all trusts, which is obviously a big difference. So the valuable succession tool that has long been used by farmers and business owners to pass down welfare, I suppose, through generations without attracting a huge tax burden is changing. And I think the thing to emphasise at the moment is that this will place an increased importance on valuing business assets, such as company shares, when dealing with estates, and it's likely to add a lot more time, cost and stress to filing inheritance tax returns. And I suspect there will be a degree of uncertainty with HMRC scrutinising these more and more and the values attached. At this moment, I suspect there will be a focus on reviewing business structures, ownerships and wills, and important that those affected to consider succession planning, which may include lifetime gifts, trusts, and making full use of allowances where they can. A big focus and a big push by the government at the moment seems to be on this lifetime gifting, or adding shareholdings to the family business to gain the most out of the new allowances, which may potentially allow owners to pass on assets to the next generation at an earlier stage. However, this in itself is not without its risks, which I'll come on to when I talk about disputes in a bit. So we've got IHT and pensions, which again were a big change in the autumn budget. Now, before the budget was announced, unused pensions and death benefits passed to beneficiaries tax-free and were not considered to be part of the estate for inheritance tax purposes. The pension pot left by someone who died before the age of 75 years old could also be taken tax-free as income without limit. There is some income tax payable by pension beneficiaries on the money they would draw if they die aged 75 or older, but none is due if they pass away before 75 years old. From the 6th of April 2027, that all changes. And again, we're looking into the consultation that comes to look at the actual proposals put forward and the logistics of this all. But effectively, unused pension funds and death benefits payable from a pension will fall within an individual's estate for inheritance tax purposes, unless left wholly to a spousal civil partnership because of a spousal exemption. One big exemption in this area, which seems to have come up, is this seems to be primarily focused at private paying pensions. We're not looking at defined benefit, final salary, or what seems to be largely classed as public sector pension schemes, as well as eligible lump sums paid to charity. So there are exclusions that have been so far included in that. It also seeks to apply to certain offshore pensions, and beneficiaries would pay income tax at their own marginal rate on an inherited pension from someone aged 75 years and older after any inheritance tax had been deducted. So for the first time, the government is looking at bringing pensions into estates to encourage them, it seems, to use them in retirement rather than using them as a way to pass wealth free of inheritance tax. So an important reminder to keep pension nominations and forms under review. It may lead people to withdrawing money from their pensions earlier to spend more on themselves or to make those lifetime gifts. But there will need to be careful consideration of the income tax requirements if income is generated from a pension or clients choose to take more from their pension, or what they may do to do that during their lifetime. And this is something that we're waiting for in terms of the further detail. But strongly we would recommend getting legal and financial advice. There are several question marks in this section, which is also something I'll come on to in the disputes section. But effectively, there's lots of unknowns about how it will work, where you've got a third party, such as a pension scheme administration, and then you've got the executors or administration of the estate. Who deals with what happens if there is a delay in the process, effectively putting in a third party, and where do the increased costs to the pension scheme, how are they going to be covered and paid? So we move on to capital gains tax, which changed virtually overnight. So pre-budget, you had your allowance of £3,000 per person per year. You had a standard rate, non and basic rate of capital gains tax at 10% and a higher rate at 20%. And then you had a capital gains tax-free uplift to market value on death. On the day of the budget, that all changed. So the annual capital gains tax allowance remains fixed and unchanged, but the increased rates to capital gains tax were applied. So main rate for non and basic tax rate taxpayers increased from 10 to 18%. Higher rate taxpayers increased from 20 to 24, and the main rate payable by trustees and person representatives will rise from 20 to 24%. So there is limited offset for increase in capital gains tax rates. Any gain realised from the date of the autumn budget will now need to pay the increased rate of tax. This includes any disposals not fully completed before the budget, and the rate of capital gains tax is still lower than that of inheritance tax. If a disposal is successful, it may help to move an asset out of an estate and save paying inheritance tax on that asset. You've got on screen about carried interest, which is more of a focus on private equity funds and how fund managers would typically receive profits, which happens before the budget directly from the fund in a personal capacity, and ensured that profits realised in that way could have been subjected to a lower rate of tax than income tax paid on salary. Now, carried interest payments were triggered when the fund hit a particular level of profitability, and once agreed amount had been hit, that would then be paid over in terms of the profits and paid to the investors. Now, this changes in two different ways. One in April 2025, so there's no change on carried interest proceeds received arising until that date. But then there would be an increase on the amount to be paid, which effectively moves from 28% to 32% for carried interest capital gains. And then you've got a further change in 2026, with more significant changes expected to affect all proceeds received on or after that date, so that they are taxed as trading income of the individual receiving them, the carried interest, and income tax and self-employed national insurance would apply. So private investment fund managers should keep track of the proposals and the consultation as they progress, as it's likely to impact and they will need to obtain advice to plan for the changes to come in due course. We've then got business asset disposal relief, which provided before the budget businesses with a lower tax burden of 10% when disposing of a qualifying asset. It was formerly known as entrepreneurs relief. You've also got investors relief, which was for qualifying investments made on or after the 17th of March 2016 to encourage them to invest new capital investment into unquoted trading companies where business asset disposal relief did not apply or other reliefs did not apply. And ultimately, there was a lifetime limit of £10 million gains that could be applied. And again, there was a change on the day of the budget that effectively meant that investors' relief lifetime allowance reduced from £10 million to £1 million. And a number of anti-forestalling rules were brought in to accompany the changes, which apply if not yet completed on an asset disposal contract or participated in a share reorganisation, effectively meaning that if you hadn't taken the steps by the day of the budget, the higher rates would then apply. And then you've got a rise in the business asset disposal relief that happens in April 2025, which would rise to 14%, and then again in 2026 to 18%. Which is likely to mean a period when business owners and investors start due diligence and as a target to complete a transaction within these dates may need to happen before those dates, so April 2025 or 26 if you want to go from 14 to 18%, to make as much advantage of the lower rates as possible. So the changes which have been largely expected to a smaller degree is on non-doms and the regime. So non-domiciled regime described a person that effectively was a UK resident whose permanent home or domicile for tax purposes is outside of the UK. It refers to their tax status and not to their nationality, citizenship or resident status. And a non-dom paid UK tax on money earned in the UK, no tax to pay to UK government on money made elsewhere in the world unless funds paid into a UK bank account. And from the April 2025, this is all due or proposed to change. So the remittance of taxation for non-UK domiciled individuals will be abolished and replaced with a residence-based regime. And effectively, that means for inheritance tax purposes, there will be exposure based on residence rather than domicile. So UK residents pay taxes on worldwide income. It will or is likely to have a significant impact on wealthy residents with international ties. And if there are distributions from overseas settlements, that will require some careful planning. After 4 years in the UK, all residents will apply to pay income and capital gains tax on their worldwide income and gains, and after 10 years pay inheritance tax on their worldwide estate. So inheritance tax will be based on tax residence as opposed to domicile status, and it's likely to impact the use of offshore trusts to shelter assets for inheritance tax purposes. and it's looking to bring a significant amount of incoming gains arising in offshore trusts into the scope of UK taxation. We also have changes to what is known protected trust status. So effectively, a protected trust status allowed foreign income and gains not to be taxed directly on the settlor, i.e. the person that set up that trust, on an arising basis, effectively extending the settlor's access to tax deferral. And it's often used to try and ring-fence certain assets abroad. Now, trusts settled by non-dom individuals prior to becoming domicile were assumed to be assets not situated in the UK and outside of scope of inheritance tax during a settled lifetime or on death, pre-budget. Now, that has changed again from April 2025, when protected trust status is to come to an end. Gains and income arising with a settlor-based, gains and interest arising within settlor interest trust would be taxed on the settlor on an arising basis if they are a UK resident and not within a foreign income and gains regime. So for non-UK trusts settled before October 2024, the gift with reservation of benefit rules will not apply even if that settlor is capable of benefiting from the trust. And again, this is designed to make sure that inheritance tax is based on residence rather than domicile status, and looking to bring in the wealth from the offshore jurisdictions into the UK. Again, if a trust leaves a relevant property regime, there will be an exit charge in respect of trust assets, and it's likely to be looked at as being a proportion of the trust assets and how much time has passed since the trust's last 10-year anniversary. So other changes that came out of the budget, and we'll work through them step by step, is income tax. Largely, there were no changes to the headline rates of 20% for basic, 40% for higher, and 45% for the additional rate. It was confirmed that there was a freezing of income tax thresholds until April 2028, and may mean thresholds increase from the tax year of 28-29. We also had changes to stamp duty land tax, which meant that from the 31st of October, the higher rate surcharge was increased from 3% to 5% for standard residential rates, and a flat rate was payable by companies and non-natural persons acquiring high rate value residential properties, increased from 15 to 17%, effectively increasing costs for purchasing second homes, buy-to-let properties, and company residential property purposes. I'm not going to cover it in too much detail, but there are certain proposals set out as to corporation tax, as to what will happen in the next few years to make some stability. But effectively for now, the corporation tax is to remain at 25% for this Parliament, with small profits rates at 19% and margin relief remaining unchanged. So some of the big changes that came out of the budget, which affect most areas, not just private client, are staffing costs. National minimum wage was increased from £11.44 an hour to £12.21 for those 18 years and older, marking a rise of 6.7%. Whilst there was no changes to employees' national insurance contribution rates, employers' Class 1 national insurance rates increased from 13.8% to 15%. And that meant also, coupled with the threshold with employers starting to pay this from falling, has meant that there will be an increased cost and pressure to businesses. A number of businesses have already announced considering reduction in staff, freezing or limiting hiring, or restructuring and increasing the cost of goods and services. But it continues to feed into the concerns about a cost of living crisis, and the particular pressure sectors at the moment have come across are care homes, hospices, charities, who are already struggling, and it may lead to more closures in due course if funding and support is not provided. Now, in addition to that, we've also got private schools and VAT. From the 1st of January, which was midway through the academic year, there was the standard rate of VAT to be charged was confirmed as being 20%, bringing private schools and boarding fees within the scope of business rates for the first time. Majority of private schools and are charitable, and charity commissions are expected essentially that they're operating with minimal surpluses or reserves. As a result, there has already been some changes which have meant to pupils being withdrawn and placed into state schools, but also that a number of schools have already closed down, which is often reported in the national papers. It may lead to other issues which may need to be addressed, like rising class sizes, more pressure on teachers, and that pupils may have to travel further to be placed in schools, especially where they've had to move in the middle of an academic year. And there is some concern about this disproportionately impacting students from particular backgrounds, such as SEND or religious, who are unable to get their needs catered for within state schools. And outside of that, a few other changes of note is the furnished holiday lets, though effectively removing specific tax treatment and separate reporting requirements so that an income and gain from a furnished holiday let will form part of a person's UK or overseas property business. And you get to effectively be treated in line with other property and income gains. Changes are again to take effect from the 6th of April 2025 for income tax and capital gains tax, and from the 1st of April 2025 for corporation tax and corporation tax on chargeable gains. And it's effectively to bring these into a line with other property businesses. Other changes: ISAs, annual subscription limits will remain at £20,000 for ISAs, £4,000 for lifetime ISAs, and £9,000 for junior ISAs and child trust funds until the 5th of April 2030. And the freezing of the ISA allowance is intended to reduce the benefit of ISAs for financial planning over time, but still to remain an attractive vehicle. In addition to that, the budget for the Ministry of Justice, which is relevant to our day-to-day jobs, is set to rise by 1.9 billion over the next 2 years, with 5.6% real terms interest for 2025-26. So much of that new money is set aside for investment in prisons and probation, rather than on the other side of the system, I suppose, which is funding for court, legal aid, wider justice system, but also on the kind of infrastructure to allow us to the court buildings, the computer systems. So there's no immediate proposal to put more money back into the legal system as it stands. So we come on to estate and succession planning. So one thing that keeps coming up time and time again off the back of all these amendments, but especially by the Labour government, is there's plenty of opportunity to gift, and that individuals should consider making lifetime gifts, particularly those that won't benefit as much with the agricultural property relief and business property relief changes. And they should look to do that before April 26th to ensure they can make use of the higher rate of relief. So effectively, if you are covered by those eligibility requirements, you could look to get up to 1.65 million if you have those qualifying assets. So the first 1 million of each would effectively be covered for inheritance tax purposes. You then have you've got your own exempt band, nil rate band of 325. And then you have an exempt amount which would get you to the 1.65 overall. And again, it's not transferable between spouses, and gifting an interest such as shares to somebody that's not a shareholder may be something you want to consider doing to allow you to help and pass as much as your business value free of inheritance tax. The other things to kind of note at the moment, you've got the 7-year rule, the use it or lose it. Gifts can be made up to at least 7 years before death, are fully exempt from inheritance tax and always have been. It doesn't seem that there are any changes proposed to this rule. And if assets can be afforded to give away, gifting remains a valuable succession tool, provided the recipients are ready to inherit. I do make that as a dispute lawyer with a slight caveat, in the sense that there are also downsides to that, particularly the risk involved with family fallout. So it's incredibly important, if you're intending to do that, to document it if at all possible, but also to take legal advice and financial advice so you can get it right and are aware of the consequences. It's also important to note that even if you don't survive the full 7 years, there is tapering relief that can apply. But if you're intending to gift, you need to be aware that you can't then live in the property rent-free. There will be rules around gifts with reservation of benefit. And you need to consider whether or not you need to pay a market rent for occupation. Otherwise, the clock for inheritance tax purposes does not start to run. You also have the gifts from excessive income. So you can make regular gifts from excess income, which you can pass on immediately free of inheritance tax, provided you can establish a pattern of giving and can prove your income exceeds your expenses. These amounts are usually exempt from inheritance tax. And smaller gifts, say up to £125, as many individuals as you like in a tax year, providing no other IHT exemption applies. You've got the annual exemption of £3,000 each tax year before inheritance tax would become due, and you can carry unused exemption forward for one tax year. There are gifts that you can make for weddings and civil partnerships, and charitable gifts, donations to registered charities, are always considered to be inheritance tax-free, whether made in lifetime or on death. There is a potential for planning with pensions, so we need to understand what is to come out of the government's technical consultation, particularly around undrawn pension pots. Whilst pensions can provide an alternative source for gifting, it's important to make sure you consider doing that carefully, because it could be premature to draw down your pension to gift now before all the details are provided. It could also result in additional income tax charges and inheritance tax should you pass away before April 2027. There is still the option, as there has been for many years, to use trusts to hold assets. And again, going back to those trusts and the qualifying amount of relief you get if you've got APR out BPR before with trust set up before the 30th of October. And that is different to those that are then set up after, given that you have £1 million for each trust, technically in terms of relief before that 30th of October deadline, and then £1 million collectively after that. There are some slight tweaks or decisions that are being taken around the current tax system for discretionary trusts and how they will pay inheritance tax. At the moment, there's a maximum rate of 60% every 10 years on the value of assets held in a trust. And there obviously are some intricate rules that go around that, combined with a 20% entry charge when assets go into the trust to result in an IHT liability. The idea being that they're looking to ensure that there is a passover of inheritance tax charged between the generations so they do not miss anyone, but effectively wealthy individuals with offshore structures as well, those are the ones that will need to seek advice on whether to transfer trust into UK trusts or to change the ownership structure to make the best use of what they can for tax efficient structures now, but the key being that everyone should consider looking at succession and estate planning, and that includes legal, financial, tax advice, and putting up the money up front to see if they can save the money in the long term. As always, you've got passing on assets in a will, and just to emphasise, between 2024 and 25, and what they believe will come in the 2028-2029 budget, they expect to collect more than 50 billion in inheritance tax alone, which would be a 19% increase. And that's more than 8 billion than they actually forecast back when the Conservatives were in government in March 2024. Average estate is liable at the moment, so the average estate will pay around 215,000 in inheritance tax, and that's from the tax year in 2022, but future forecasts all point upwards on that issue. You can still have up to £1 million if you're married or in a civil partnership to pass without inheritance tax becoming due, and anything you leave to your spouse or civil partnership following death free of inheritance tax means that you can pass to a large degree your entire estate without inheritance tax being due, because you can pass on the nil rate bands as well. One suggestion that has come out from a lot of discussions, particularly around the kind of farming community, is whether or not it would be appropriate or something that can be put in place is life assurance or insurance, basically to safeguard against inheritance tax liabilities, rather than having a large lump sum and no means to pay it, to take out insurance to cover the liability, to ensure that there isn't a forced sale to pay the inheritance tax bill. It's not designed as a method to stop inheritance tax, but rather to assist beneficiaries of the estate to meet the liability in the form of a lump sum of death of the policyholder. So again, crucial to obtain professional advice to help calculate the size of the estate, the amount of tax that would be due, and the size of the lump sum required on death and the cost of the premiums this would result in. And then we have the work around pensions is quite a lot, and I think the detail has not yet come through or been released because it's all very technical, but those with substantial pension savings probably need to consider reconsider their investment strategies, whether they need to increase or decrease drawings, reassess which assets to deplete for retirement expenses, and ultimately looking at getting advice, legal, financial, tax across the board, because spending now money up front should help to look to reduce the liabilities in the future and the options available. So outside of estate and succession planning, there is also other considerations that need to be taken into account. Deliberate deprivation of assets, particularly from a care home or care fees perspective, it effectively exists in order to avoid people gifting assets or converting them into a disregarded form to avoid or reduce the contribution they would otherwise have to pay towards care and support costs. So if a local authority can show that an asset was deliberately disposed of to avoid paying for care, then the value of that asset will be counted in the means test that they carry out as part of the financial assessment. The local authority just have to show that avoidance of care and support charges was the motivation or significant motivation for making the disposal. And whilst the time that elapses between the date of disposal and entering into care accommodation is significant, it's not decisive. The likelihood is if an individual makes a disposal while fit and healthy and some years before going into care, and there's no evidence like a document or legal advice that has said their primary motivation is to avoid care, then it may be that that doesn't fall into the financial assessment. But contrary to popular belief, there is no time limit for that local authority to look back. So it's an open-ended look that they can do. So if there's even a motivation they can show, they can look to claw that back in. Then you've got lifetime gifts. So you need to be very careful around the two presumptions that often come up in these situations. You've got the presumption of advancement and the presumption of undue influence. Now, the presumption of advancement effectively states that you assume the transfer of property or funds is a gift unless proven otherwise. And it's commonly used when parents or spouses give money or property away. And then there's the presumption of or presumed undue influence. It's something to be very careful, particularly with lifetime gifts, where you're an individual in a position of trust and confidence, and usually that would be between spouses or particularly between parent to child, and in certain cases, doctor-patient, for example, you are assumed to have been in a position of trust and confidence. And where there's a transaction that has been made, it effectively means that you have to give a cogent reason or an explanation for it. And the burden of proof is on you as the person receiving it to provide that, rather than the person that is trying to allege that it's been done by undue influence. The presumption works in their favour. You've got tax implications and increased scrutiny by HMRC. So the autumn budget announced plans to drive to increase the scrutiny of tax compliance and debt management. They plan to recruit another 5,000 additional compliance staff, including many VAT inspectors, another 1,800 additional debt management employees, and they have a number of IT upgrades to overhaul their systems so they can follow up on their inquiries. And there's also the ongoing change to tax rules. So they can introduce legislation to make tax consequences the same for those using alternative and conventional financial arrangements. Going hand in hand with that as well, if you fail to pay your tax on time, there is increased interest charged on late payment, and it's going up by 1.5%. So that is from April 2025, it'll be 8.75% that they can charge. So they're focused on increasing the tax that they receive. Other considerations are post-death variations. So you could enter into a deed of variation for up to 2 years after somebody's date of death, and it varies the terms of the will, deceased will, and can effectively vary the liabilities that could attract to inheritance tax or capital gains tax. Depending on how you do that, effectively is able to rewrite the certain terms within that will and can be used to correct mistakes, divert monies to other beneficiaries, or maximise the available tax reliefs. And then you have charitable giving. So IHT liability could fall from 40 to 36%, where an individual leaves 10% or more of their net estate to charity. So it may see people looking to leave some gifts to charity and make charitable donations part of their mitigation on their tax liabilities by part of their planning for the future. Charities themselves continue to face a challenging fundraising landscape, so they have been particularly hard hit by the staffing cost increases, and they feel at the moment that the changes to inheritance tax will be minimal or marginal at best to their sector, even if people do get that benefit from 40 to 36%. So looking at slightly different over the other side of the road is private client disputes. What impact will or is likely to fall from the autumn budget? So it's probably fair to say that disputes in our area, so that's disputes in wills, trust, probate, maybe even the court of protection, are already at an all-time high. Effectively, there's many different factors that kind of play into this, and some of them are on the screen. So the cost of living crisis, reliance or expectation of inheritance, the increase in homemade or DIY wills, and that can include lasting power of attorneys. You've got complex family dynamics, particularly in the age of stepchildren and cohabitating partners and families. An aging population, an increasing number of deaths. You've got an increase in aging diseases and care costs, the increase in use of lasting power of attorneys, the increase in wealth due to the increase in property values and pensions, particularly by those held in the baby boomer generation. You've got increasing gifts to charity, greater public awareness of legal rights, and different funding methods to allow individuals to dispute matters. So against all of that, is it likely that the autumn budget will impact on this growing trend? So in the short term, because the significant changes to inheritance tax are not due to take effect until April 25 and 26, the feel at the moment is unlikely to be an immediate impact on inheritance disputes. In terms of the inheritance tax changes, we feel that there's a large field that effectively is unlikely to impact on estates with a lower value, as the nil rate band and residence nil rate bands are unlikely to change until 2030. In the long term, the higher value estates are likely to be affected the most by the changes. The autumn budget has brought farmland shares, pensions into the definition of net estate and taxable for inheritance tax purposes. It is likely that the high net worth individuals will face higher inheritance tax liabilities, which may or could reduce what is available for beneficiaries. It could leave beneficiaries with less motivation to contest an estate, although in my experience, if you've got one, it's unlikely to change much of that. But it could focus on them making sure they are targeting what they are doing or reducing their costs to get to the point where they could potentially settle. It may lead beneficiaries to actually fight to secure their share and entitlement of what's left, because there is less left in the pot. But there would likely be a renewed focus on trying to resolve matters amicably to see if court proceedings could be avoided, given that the associated legal costs could be avoided and are going to be a big factor if there is less to fight over. But there still remains a big financial incentive to dispute the higher value estates due to their size, and as more assets will fall into the pot. With the cost of living crisis, this has been a big factor behind a number of inheritance disputes, and if anything, household expenses are getting worse, not better. So there's an increase in energy prices, water bills, council taxes due to rise, and businesses have indicated that they're passing on their increased costs to goods and services. At the moment, there is concern about inflation and figures like contrasting figures, and we're due to hear in March about the economy, will determine whether or not there will be any changes and reductions to interest rates. And we've also got the overhang of the increased government cost towards borrowing and the uncertainty about Trump and whether or not the pound or dollar goes up in terms of how that all works out. And many people are still looking for ways to support themselves and their families. Lifetime gifting, I mean, there is a big push for lifetime giving, and probably as a dispute lawyer, I see it when it all goes wrong. But Giving away assets early or during lifetime, particularly when motivated by mitigating tax liability or future care costs, is not without its own risks. So it can raise many different legal and tax issues. The increasing of number of tax gifts being made without legal assistance means they could be more susceptible to challenge on death, but also to tax implications. I mentioned earlier about gifting with reservation of benefit, but a lot of people do not know about the rules of paying market rent for the property they live in, even if they give it away. And that inheritance tax starts from the moment, the clock for inheritance tax stops if they're living in it as a gift with reservation of benefit, not the 7-year rule that often they quote. You've also got the deprivation of assets, which could then come back to haunt if a local authority then seeks to claim that back into the pot to pay for care costs. But the likelihood is that lifetime gifts will come under greater scrutiny, and there will be potentially an increase in claims aimed at setting these aside, but also could have potential complications where other issues such as divorce becomes an issue with those families. Pension pots as part of the net estate. Given the involvement of pension administrators and the fact that the technical consultation is still yet to answer the big questions of how this would work, there's big question marks over what will happen if there's delays in the administration process, which is often out the hands of those trying to administer. You've got the probate history, you've got to go through HMRC, and now you've got a third party being involved in that process. Whilst discussions go on about clarifying the value of the pension scheme and the wider estate, who is going to pay or how is the IHT to be apportioned? Due to the additional work, I would expect that the pension scheme is going to have to get additional staff or have to incur additional costs, which will then have to be passed on. And given that the pensions will form part of the estate, my concern is that this may lead beneficiaries to consider and make claims against the pension pot, particularly if it's distributed differently in the terms of an individual's will or under the intestacy rules, and if it's particularly different from what they have put in a nomination form. The scrutiny of completing a nomination form versus in doing a will is effectively not that great. It may lead to increases in claim about the administration of the pension scheme, obtaining the information and documentation from the pension trustees, challenging the decisions of the trustees in that pension scheme. It would also be interesting to understand how pensions will feature within claims for reasonable financial provision under the Inheritance Provision for Family and Dependents Act 1975, given the change of how pensions are being classified. Discretionary trusts, we've got a focus and increased use of discretionary trusts, and the likelihood is that there will be a lot more disputes arising on how to seek and obtain information and documents relating to these trust structures from trustees. I suspect there will be a greater importance placed on how the trusts are managed and administered, and there may be a greater challenge to the decisions made by those trustees. The other increasing importance will be on the identity of those trustees, given how much control they have over the distribution of the income and capital from that trust. So HMRC have already said that they are looking to increase scrutiny over tax matters, and that continues on with the valuation of assets. It is more important than ever to obtain accurate valuations, particularly for agricultural property relief and business property relief assets. And there is an existing strain on HMRC's valuation resources. The likelihood is that there will be a greater administrative burden. There will be delays faced by estates during the administration process, as this can be and probably will look to be challenged more and or settled by HMRC. I'm looking forward to seeing how HMRC will grapple with other issues such as digital assets, such as crypto, non-fungible tokens, but also with cross-border income and assets, given the rules and ways to get hold of documents from cross-border jurisdictions is often very different from our own. The DIY culture I've mentioned here, but DIY wills have been around for years and increasingly so DIY lasting power of attorneys. But what seems to be on the rise more recently is the number of lay power of attorneys and personal representatives, many of which I think are doing it because they want to try and minimise the cost of involving a professional. Some may be doing it with a more kind of corrupt agenda, might be the way to look at it, but we're seeing, most certainly from my perspective, I'm seeing an increase in misappropriation or financial abuse claims. And given that they are happening from lay power of attorneys, that's often coming through in the estate administration process. Often with no professionals having been involved, so there's no monitoring and oversight. But it also seems to be an issue with estate and tax planning, with many turning to cheaper solutions to provide advice on setting up trusts and lifetime gifts, which often need to be undone. A good example is asset protection or family protection trusts, which are often sold on the basis of things that they cannot promise and do not actually achieve. And takes often a lot of work to unpick and a lot of costs, if you can unpick at all. And then I would expect, given that there's an increased focus on estate succession and tax planning, that there would also be a big reliance on professional advice and support, which may in turn lead to an increase in professional negligence claims against those sorts of professionals if the advice doesn't factor into account the correct considerations or issues, or does in fact lead to overall family disputes arising. So there's lots of different factors, and I'm not saying they will happen, but they're kind of the initial thoughts that I have coming out of the autumn budget. A lot of changes were proposed and obviously subject to consultation, and there's still a lot ongoing, with the devil being in the detail. However, many changes are complex, and often what happens is that disputes go on the rise because effectively when new legislation comes in, there is that area of grey that is yet to be provided for, so you have to put the skin on the bones. And it may be a number of years before some of the case law comes out to get the fine tuning done in terms of the detail. So whichever way you look at it, I think the key is that there is an increase in the changes, which is likely to lead, good and bad, to changes and challenges and opportunities in the years to come. Whether you're a private client, non-contentious lawyer or a disputes lawyer, I certainly think this area of law is going to keep us entertained for years to come. So I'm just going to finish off on the future, very conscious of time, but looking forwards. So in the next month or so, the Office of the Budget Responsibility is due to publish an economic and fiscal forecast on the 26th of March, which will then lead Rachel Reeves to making a statement in the House of Commons. So Rachel Reeves is committed to provide a single fiscal event each year to give stability and certainty to the upcoming tax years changes. And I appreciate her focus is on growth and the economy rather than taxes. And it is expected that effectively this announcement or this report will govern how she then chooses to deal with the spring budget, which is due to come forward in around April. If the report supports that the country supports Rachel Reeves' view that the country is on track to meet its own self-imposed fiscal rules, it might not see any major policy announcements. However, I think that's probably a big if. So the budget that was previously announced with the borrowing buffer provided was just under 10 billion. And historically, that's quite a low figure, which didn't provide much wiggle room should something go wrong with all the forecasts and changes promoted. And with so many different inputs into that forecast, it's important to emphasise that there's no certainty on the amount of fiscal headroom that is left. So if after the report comes out from the Office of Budget Responsibility and they announce that targets are not on track, the Chancellor has some options which very broadly fall into 3 different brackets. You've got tweak the rules, the fiscal rules, cut spending and increase taxes. And given that Labour's manifesto or after the autumn budget, they mentioned not increasing taxes, it is rather difficult to see where they would have to come back on apart from spending cuts. Other than that, they may have to take a reverse turn and increase taxes. And obviously that's all to come in the next couple of months. The changes that came out from the autumn budget are due to go through in large in the finance bill, which should be enacted by the end of March 2025. In terms of other developments, the spending review announced after the last election isn't due to conclude until June 26, which is when the Chancellor will then announce departmental budgets for its own government in 29 and 2030. But there are many different consultations issued or being published in 2025. You've got the taxing carried interest, which consultation on which closed in January 25. You've got abolition of non-domicile status. So we're waiting to hear what that looks like in terms of the amendments to be proposed. There was some suggestion by the Chancellor that those would be softened and that amendments would be made to the finance bill. And we're just waiting to see what they will be. Inheritance tax changes. So the consultation on pensions for inheritance tax purposes closed in January. So we're waiting to see the government's response on that. The technical consultation on agricultural and business relief was promised in early 2025, with details to be coming out soon. We've got a whole profile on making tax digital for income tax. So guidance on that is expected to be released in 25. The government's looking at a roadmap for corporate tax, which again, I think there's a proposed consultation on several issues in 2025 up and coming. UK's international tax rules consultation promised in spring 2025, and indirect taxes anticipated that 2025 will be an eventful year across the board, with a wide array of updates to legislation, shifts in policies, and significant developments in case law. So the things to look out for in terms of consultation on reforms. There's one ongoing at the moment on remote gambling and consultation on the move towards mandatory invoicing, which is open until the middle of early May. And I think we're looking at there may be some changes in legislation depending on how Donald Trump decides to employ global trade deals or impose tariffs. So it doesn't look like the Chancellor has any intention to roll back the increased costs to employers. And they're due to take effect from April. And then you've got tax administration. So following the autumn budget, consultations are being published on modernising some areas of tax administration. So simplifying the taxation of offshore interest. Both of those consultations, have already closed, and a response is expected shortly with some legislation to be published. So there's so much going on in our area of law at the moment. And consultations coming out from left, right and centre, largely to put the detail behind it and to make sure they've gone out to the professionals to make sure it all works, and also to see what else they can do in terms of proposals for the future, I imagine. So there is a big focus and prioritisation, I think, on estate and succession and planning, including lifetime gifts and trust structures. And I set for the next few years, I think the focus will be quite busy for private client practitioners across the board, particularly with the great wealth transfer on the horizon. And baby boomers looking to pass on their assets to the next generation. There are a lot of changes proposed in the autumn budget, and they are clearly subject to the consultations and the devil's in the detail. Many of the changes are complex and will take some time to work through, but for now it seems that the focus should be on people taking the steps to gather together their information documents so that they can do the estate and tax planning, make plans early, which is key, and put in place your options and get that professional advice, which is vital. So an ever increasing number of estates are already liable to inheritance tax, and I think unfortunately that's going to increase more and more. So that's a kind of whistle-stop tour through a very complex area. I appreciate there's a lot of questions that were submitted before, and I appreciate there's probably some that I've missed in all of this, but if there are any more, I will try and tackle them as best as I can do. And if not, I can come back afterwards. So I will go to the chats now. Can't see any in the Q&A, so I will leave that just 1 second. So I've got one from Victoria about British nationals returning to the UK after working abroad Will their worldwide estate be immediately under the IHT umbrella, or will it be after 10 years? I will need to have a look at that and come back to you. So I apologise, I can't address that at the moment. The only other questions I had pre-submitted. Quite a few questions, I think, very specific ones that have come in. I would imagine some of them are with a focus particularly on cases that they've got before them. Budget for farmers and landowners. The changes at face value are deceptively simple. Could you explain the nuances relating to IHT relief and why there is a great deal of concern amongst farmers and landowners? I mean, the nuances, like the devil's in the detail, we're yet to hear that. But the kind of key thing that farmers and landowners are particularly concerned about, or from what I can understand, is effectively that you've got a large amount of their wealth is tied up in the actual business. So the land, assets, they're not liquid rich, they're capital rich, if you want to look at it as that on paper. And so when you have to pay IHT, there would be no other form of being able to pay that unless you sign, like sell off and liquidate the assets in order to pay the inheritance tax liability. That in itself causes issues because they need that asset, or they need those the land to do their business. So whether that's agricultural business itself. So it was a concern overall that actually getting rid of the relief is going to cause great issue. Now, if you are a business that is on the threshold of 1.6 million, and I'm not sure many farmers, and particularly those within NFU, can provide the details of the figures that of those that are proposally affected, then you aren't going to be affected a great deal by what is being proposed. But it's those that are arguing it's between that 1.65 and above, and those that aren't rich, like mega rich or mega wealthy, that effectively you're hitting the ones that are working hard, and the ones that actually will then lose out on being able to pass that family business down the generations. So effectively, I think the biggest issue that they have is that they have already worked very hard for many years to get these businesses together, and that's the same with business property relief as well. And they're being left with little to no option but to be having to pass down the assets early, which could cause itself some issues, or they're going to end up with a big tax bill, which they previously wouldn't have done. The government has indicated that it has no intention to change its proposals as it stands on APR or BPR. That is despite all of the challenges that are being made and all the protests. I don't know if that will change, but obviously there's a great deal of pressure that the unions are putting on, and they continue to monopolise the protests that are going on at the moment. Best way to deal with pension changes. So I've got a question around pension changes in wills, in terms of how best to deal with pension changes in wills. I think the problem a lot of people have at the moment is that although the consultation has closed, the guidance and actually the details of what to do has not yet been released in great detail. So in terms of it's a kind of a matter of wait and see, because if you take action too soon, you may do it when the rules are actually completely different from what they turn out to be. It's also unsure if the government will go through the actual level of logistical detail that is required. There are some issues, I think, around how pension schemes relate back into like the administration side versus the estate side of the administration process. So there is going to be a lot of question marks, and unfortunately, it's not going to be something we will be able to answer until we get the detail come out. I think other than that, unfortunately for today, I don't think any of the questions are ones that I can specifically answer, but I will anticipate to get back to you on those by the end of this week. Otherwise, I mean, in terms of wrapping up, thank you so much for taking the time to listen. If there is anything that comes out after today, please feel free to drop me an email. My email address is sarah@culverlaw.co.uk. I am a member of the council member of Bristol Law Society. So if there's anything else you'd like to see specifically private client focused that would help, whether something more detailed on this issue or another topic entirely, or if you'd even like to offer to speak, please let me know. We are planning to have a private client conference, which hopefully will take place in April of this year. with details to come out soon, but all details will be on our website. Other than that, please let me know if there's any questions arising afterwards, and I'll get back to you for those that have got them separately by the end of the week. And thank you so much for listening.